The Horse of Lords in Solomon versus Solomon and Co. Limited laid down that a company is a person distinct and separate from its members, and therefore has an independent, separate legal existence from its members who have constituted the company, but under certain circumstances, the separate entity of the company may be ignored by the courts. When when that happens, the courts ignore the corporate entity of the company and look behind the corporate facade and hold the persons in control of the management of its affairs liable for the acts of the company. Where a company is incorporated and formed by certain persons only for the purpose of avoiding taxes, the courts have discretion to disregard the corporate entity and tax the income in the hands of the appropriate assessee. In Dinso Mackenzie patented case, it was held that the company was not a genius company at all, but merely the assessee himself distinguished that the legal entity of a limited company, the assessee, entered huge income by way of dividends and interest. So he opened some companies and purchased their shares in exchange of his income by way of dividend and interest. This income was transferred back to assessee by way of loan. The court decided that the private companies were a sham and the corporate veil was lifted to decide the real owner of the income. In the instant case, the four private limited companies were formed by the assessee purely and simply as a means of avoiding tax, and the companies were nothing more than the facade of the assessee himself. Therefore, the whole idea of Mr. A was simply to split his income into four parts with a view to evade tax. No other business was done by the company. Hence, A cannot be regarded as separate from the private limited companies he formed. Sound Syndicate Limited, a public company, its articles of association empowers the managing agents to borrow both short and long term loans on behalf of the company. Mr. Liddell, Mr. Liddell, the director of the company, approached Easy Finance Limited, a non-banking finance company, for a loan of 25 lakh rupees in name of the company. The lender agreed and provided the above said loan. Later on, Sound Syndicate Limited refused to repay the money borrowed on the pretext that no resolution authorizing such loan have been actually passed by the company and the lender should have inquired about the same prior providing such loan, hence company not liable to pay such loan. Analyze the above situation in the terms of the provisions of doctrine of indoor management under the Companies Act 2013 and and examine whether the contention of Sound Syndicate Limited is correct or not. Doctrine of indoor management. According to doctrine, persons dealing with the company need not inquire whether internal proceedings relating to the contract are followed correctly. Once they are satisfied that the transaction is in accordance with the memorandum and articles of association, stakeholders need not inquire whether the necessary meeting was convened, convened and held properly or whether necessarily resolution was passed properly. They are entitled to take it for granted that the company had gone through all these proceedings in a regular manner. The doctrine helps protect internal members from the company and states that the people are entitled to presume that internal proceedings are as per documents submitted with the registrar of companies. Thus, what happens internal to a company is not a matter of public knowledge. An outsider can only presume the intentions of a company but do not know the information he is not privy to. If not for the doctrine, the company could escape creditors by denying the authority of officials to act on its behalf. In the given question, Easy Finance Limited, being internal to the company, external to the company, need not inquire whether the necessary resolution was passed properly, even if the company claim that no resolution authorizing the loan was passed. The company is bound to pay the loan to Easy Finance Limited. The company is bound to pay the loan to Easy Finance Limited. Naveen incorporated a one-person company, making his sister Navita as the nominee. Navita is leaving India permanently due to her marriage abroad. Due to this fact, she is withdrawing her consent of nomination in the said one-person company, taking into considerations the provisions of the Companies Act 2013. Answer the questions given below. If Navita is living in India permanently, it is mandatory for her to withdraw her nomination in the said one-person company. Yes, it is mandatory for Navita to withdraw her nomination in the said one-person company as she is leaving India permanently, has only a natural person who is an Indian citizen and resident in India shall be a nominee in one person company. If Navita maintained the status of resident of India after her marriage, then can she continue her nomination in the said one person company. Her marriage, then can she continue her nomination in the said one person company. Yes, yes, Navita can continue her nomination in the said one person company if she maintained the status of resident of India after her marriage by staying in India for a period of not less than 120 days during the immediately preceding financial year. Examine the following whether they are correct or incorrect along with reasons. A company, being an artificial person, cannot own property and cannot sue or be sued. A company, being an artificial person, cannot own property and cannot sue or be sued. Incorrect. A company is an artificial person as it is created by a process other than natural birth. It is legal or judicial as it is created by law. It is a person since it is clothed with all the rights of an individual. Further, the company, being a separate legal entity, can own property, have a banking account, raise loans, incur liabilities, and enter into contracts. Even members can contract with company, acquire right against it, or incur liability to it. It can sue and be sued in its own name. It can be everything which any natural person can do except be sent to jail, take an oath, marry or practice a learned profession. Hence it is a legal person in its own sense. In its own sense. A private limited company must have a minimum of two members, while a public limited company must have at least seven members. A private limited company must have minimum of two members, while a public company must have at least seven members. Correct. Section 3 of the Companies Act 2013 deals with the basic requirement with respect to the constitution of the company. In the case of a public company, any seven or more persons can form a company for any lawful purpose by subscribing their names to memorandum and complying with the requirements of this act in respect of registration in exactly the same way two or more persons can form a private company.